Welcome, everybody. This is Charles Cook. It is great to be with you today. As you all know, I'm actually broadcasting for the first time, I think, on Twitter, although I'm not really quite sure. I'm checking right now. But if I am, great. If I'm not, I should still be on Facebook and YouTube. It's great to be with you today. I wanted to really start off today by talking about what has happened in the last week with a couple of big pieces of litigation. Sorry, the first piece was last week. Early last week, we'd filed a preliminary injunction, which is basically a request to a judge to say, look, we can't wait the normal 6-10 months on this case. We have to have a decision quickly because something's going to happen. But we couldn't file that until we could confirm that there was a secondary lottery. We were able to confirm the secondary lottery, and we filed the preliminary injunction right away. And that was last Monday. And after we filed, maybe it was a Friday, maybe it was a Thursday, Friday before. The judge then said, oh, well, a preliminary injunction the next day, I'm going to set your hearing for August 27th, a month later, which is fine in the facts that we then had. The day after the judge set this date, the government conducted a secondary lottery. Now, I will tell you that they could have told us. They could have said, because we alerted them that we were filing a preliminary injunction, because we have to say, hey, we're filing a preliminary injunction. Do you agree to stop what you're going to do, or are you going to fight it? And I said, no, we're going to fight it. They could have told me then, hey, we are going to go ahead and do this on Thursday. And if we'd have known that, instead of filing a preliminary injunction, we would have tweaked a few things, and we would have filed a temporary restraining order, which is an even more immediate. And it's a more immediate relief because something urgent is going to happen right now. It has to be stopped. Otherwise, it's irreparable harm. But unfortunately, we couldn't tell that. I mean, they hid the fact to the public about what they were going to do and when they were going to do it. Because if we'd have known, I think we may have prevailed on the TRO. But instead, by the time we had the hearing with the judge, which was last 2 days, I said, this week, oh my gosh, it was Monday, when he set the hearing for Monday from last Thursday, then by then, this lottery had already been conducted. And I think the judge ultimately was convinced that, well, lottery happened, all right? So the harm has happened. I can't go back and fix that. Now, what we were asking the judge to do, to be clear, was to stop immigration from accepting applications from people who were beneficiaries of multiple applications from employers that were not real. The USCIS knows exactly who filed multiple applications. They know which companies filed multiple applications. They know this because in response to our TRO, they said that one of our plaintiffs had 2 employers file for them, which is fine if they were real employers, okay? But our argument and our case is about those that are filing on fraudulent employers. And I think it was the judge, even though he ruled against us, and I don't think he was predisposed to that. I think we had a good argument before the government started. And he said, look, I don't think I can do this today, so I'm not, but we're going to have a hearing on August 27th. And really that is, well, it's a preliminary injunction. And again, our standard is higher than if we just waited. And technically we could just wait. I mean, that's an option. We could say, you know what? We're going to withdraw the preliminary injunction and go into a regular summary judgment discovery mode because the harm for this year has already happened, except I think there could be a third lottery. If you look at the numbers that immigration has selected, they are about 10% lower than last year's numbers that they used to get to the cap. And again, I don't have the top of my head if they got to the cap. I don't think they did. I think they were short of the cap. That they may not have enough. And one of the things they said in oral argument is, hey, if somebody commits fraud, then of course we'll just put that number back in the H1bs for that year. Except they've never done that. They've never said, hey, we got 10 more visas we can have a lottery for. They've never done it. So, I mean, I'm suspicious about the veracity of that particular statement in regards to how USCIS operates. I'm sure they told their lawyers that, but the reality is that that doesn't really happen. And so we were torn. Should I keep with the PI in case it's a tertiary lottery, or should we go to a regular system and fight to stop the secondary for this happening next year? That would be an easier win for us because the standard is lower. I mean, again, we have to show irreparable harm at the preliminary injunction stage, whereas we don't have to show that. We just have to show, hey, they're wrong. They're just literally wrong. So we're still mulling that, talk to the government about doing this. We're supposed to have an in-person hearing, probably see if we can defer that to a video hearing if we go ahead on the 27th, only because of the COVID travel stuff going on here. Even those of us that are smart enough to get vaccinated don't necessarily want to get on an airplane with a bunch of people that aren't. And going to D.C., there's a lot of people that aren't. So that's where we are on the H1b litigation. We're still fighting for this because it's not fair. It's not a fair playing field. And I kept telling the judge, it's not fair and equitable. You can't have a lottery and pretend that it's fair when it's inherently not, because the rules you have created have allowed it not to be fair. Because think about this. If, let's say we lose the case. All right, we lose. All right, they can conduct the lottery however they want to. Well, that means that if you're an potential H1b seeker, that you would be a fool not to try to find alternative employers and submit 50 applications. You'd have to be a fool, really. You'd have to tell every employer that wants to hire you, you know what, put an application in and I'll go to the first guy who gets it. Now, that's not the way this is supposed to work. We all know that's not supposed to be like that. But if the USCIS is going to allow gaming of the system, then everybody should be gaming the system, right? That's how it should be. And that's just stupid. It's unfair to employers. It's unfair to the applicants themselves. We all know that. So there you go. That's the H1b stuff. And I probably should have put up a little banner that I was talking about that today. So if you go back the next little bit, you would see me talk about the lottery abuse. So the last few minutes are about the lottery abuse. But we will keep fighting on that, and we will keep our plaintiffs apprised of that application. The second thing I want to talk about today is the USCIS delayed litigation stuff. Okay, so the delayed litigation part of the case is what's going on. What is this? A lot of you that listen to me regularly in our impact litigation team know that we've been planning this for months, and we were finally able to get everything put together and file. So what this is actually a really powerful, I think, piece of litigation, because if immigration really believes that they have a legal obligation to use the numbers every year, this is a perfect tool for them to get court coverage and agree to an injunction and say, yes, we have to reserve these visas and use them this year. We agree with that. But maybe they think the law is a little unclear and whether they can do that or not, but we know a judge can order it to have happen. And while this is not the first year they wouldn't have used all the visas, really the first year they haven't used massive numbers of visas. Now, we don't yet have the third quarter USCIS statistics, which are, right, by the way, a little late and maybe intentionally so. But we don't know what they did in the third quarter. We know in the first and second quarters of the year, they only issued about 30,000 green cards for employment-based people, all of them. And we know they started the year with close to 270,000 that they could adjudicate. And then they allowed 200,000 people to file applications because they got more numbers. We know all of that. So why aren't they adjudicating these? Well, first of all, half the cases, if you look at their own report, half the cases are in field offices. So they're sitting in Detroit, Newark, Atlanta, LA, Omaha, Nebraska for interviews. And the USCIS is not doing the interviews because of COVID. So cases, for the first, I need to change the first rule. Why are you interviewing these people? This is just stupid. Look, unless there's indicia of fraud, no interview is needed. That's the way that's been the policy for almost 20 years until Trump and his minions changed it. But second, why aren't you pushing to get these done? You're going to lose these. These are not immediate relative cases. They're not going to lose. All right. You need to be doing these. Very few of these, by the way, are done at consulates, which is why we did not sue the Department of State. Very few of them are done at consulates. So it's really all our clients have adjustment of status applications pending. The second part of the case, besides, is, hey, you need to use these, and if you don't, judge, reserve the numbers for next year. The second part of the case is, look, it's unreasonable to take a year. Your own statistic, your own memo, public memos say that it takes 93 minutes to adjudicate one of these cases. So why are you taking years? Why are you taking a year? Why are you taking 6 months? You didn't even issue receipts for like 4 or 5 months, which is wildly unacceptable in and of itself. But just because immigration says it takes 15 months or 24 months or 37 months to do a green card application does not mean that's reasonable, because reasonable is what reason dictates, not what the person who defines the term for themselves dictates. And we know that historically that they have done 6-month green cards. There's no reason every one of the people that filed in October, November, and December aren't approved. There's no reason for it. None. They could do all of them. So there's a mandamus component to this. You need to order them to do it within the time frame. All right. Now, obviously, we have 125 clients. They could do those. They could do those in a week with a couple people. Think about it. Let's say an hour and a half, 125. Put in a little overtime. 3 people working for the government could get all of those adjudicated, and our case would be gone because we're not using a class action. But we are asking for a universal nationwide injunction. So what we will be, we're asking for a nationwide result, but we don't need that for our clients to be successful. By the way, we're still accepting individuals. We can add people to our complaint. If you're interested in doing that, you can certainly join the complaint. And in fact, I'm going to put that up so that you can see the waiting list. If you want to join this complaint, we have, before we file the preliminary injunction, there is an opportunity to become a plaintiff in the case, and we're happy to do that. Here is the email. You guys go to this link right here, press that, put down you want to be part of consider it as a plaintiff, and we'll get back in touch with you. So think about that. Now, why are we doing this? And I posted on Twitter about this, and some snide trolls like, oh, it's not going to make any difference. You need to pass the Eagle Act. You need to make everybody on the same playing field, even though then it makes the playing field unequal for everybody. Here's the rationale. So this year, about almost 130,000 visas came over from family that were unused last year to the 140. So that's about 270,000. We've already been told that an equal number of family cases are going to come over this year. So another 290,000 visas. Now, between that's well over 500,000. It's well over 500,000 people. In the backlog, near as we can tell, is between 700,000 and 800,000 people, more or less. Okay, not the 1 million, whatever. It's 700,000 or so that are in that backlog. So that immediately, just these 2 years, if you used all these visas, and almost all of them are going to, there's different categories, of course, but most of them are going to go to Indians to reduce the backlog and Chinese to do the backlog. They just are. That's how those numbers are going to work. Because once you get current, which they already are for all the other categories, it's going to go the oldest cases first in each category. So, Indians are going to use 80% of these numbers. And then look at the third year from now. So we look at, instead of 2022, 2023. Well, COVID's not going away. The Department of State's not going to magically start doing 100% interviews. They're just not. So another 100,000, 90,000, 150,000 are going to float over back to employment. Another year of 250,000 visas. So in 3 years, you're going to wipe out 75 to 80% of the backlog, if not more, as part of this. And this is what this litigation is designed to do, is to ask for what we are allowed to have under the law and to fix the problem without harming anybody else. Bam. There you go. Hard to put in a tweet, but easy enough to understand if you've got just a little bit of a brain. So that's where we are with that. We are moving forward with the preliminary injunction on this. We intend to have that, I think, in by next Friday is kind of the goal at this point. We have been assigned Judge Clark in the District of Maryland for this case. She is a President Clinton appointee, has ruled pretty nicely on some prior immigration issues. So we feel fortunate to have her as a judge. Not that judges make a difference, as we learned in the EB-5 case, but judges are fair, and good judges are eminently fair. And she appears to be a very, very good judge. So we're very excited about that. Jeff Joseph is you'll see his name is the lead lawyer in the case because he's admitted to Maryland. The rest of us will be entering our appearance this week. So that's kind of where we are on that litigation. Now, the other thing that I wanted to talk about today is immigration reform, immigration bills, and what's called the reconciliation part. I'm going to add a banner here. So we're going to talk about this. Make sure I spelled reconciliation right. I believe I did. So where are we? What's going on? Look, one thing to understand is that this Congress, and frankly no Congress as far as the eye can see, is going to handle a standalone, by itself, immigration bill. Whether it's the DREAM Act or whether it's the Promise Act or legalization for agricultural workers or any other bill, EB-5, the rewritten EAGLE Act, which is just, same show, new tune from last year. None of those bills are going to pass on their own. None. So there has to be another vehicle, another bill that has to pass. And then one of those bills will have to be part of it. So there's a process in the Senate. Now, of course, all of these bills, some of them have already passed the House of Representatives, the DREAM Act, the Promise Act, legalization. It's all passed the House of Representatives. I mean, it's sitting in the Senate. But the Senate has this rule called the filibuster, which they refuse to get rid of, which basically says unless you have 60 votes, you're not going to pass anything, even though you only need a majority to pass it, because you can't have a vote unless you have 60 votes to have a vote. So basically, hey, we want to have a vote. All of those in favor of having a vote raise their hand. And if you don't get the 60, you can't have the vote, which only requires 51 with the vice president. Democrats have 50 votes, 51 with the vice president. So there's a process in which there are some bills, and one bill in particular, on which they only need 51 votes, or 50 plus the vice president. And that's called reconciliation. The reconciliation is a budget bill. So this was designed to, in several years ago, to allow Congress to pass controversial bills that involve on the budget, because budgets are must-pass things. You have to have a budget. You have to authorize money. If you can't authorize money, the government shuts down, and you don't want to be held hostage to the filibuster for that. Why you'd want to be held hostage to the filibuster for anything, I'm not really quite sure, but that's not for this show. So the reconciliation bill. So what's the deal with this? Well, in order to get to the reconciliation bill, the majority leader has to believe that he has all 50 Democrats to vote for it, because no Republican is going to vote for it. Now, the reconciliation bill they're talking about is upwards of the budget, they're talking about $3 trillion. Now, that sounds like a lot of money, because it is a lot of money. It is an enormous amount of money. But in that reconciliation bill, where all this money is being awarded out to all these different constituencies, there have been in the past immigration bills attached to reconciliation bills, as well as the other must-pass budget bills. Like, for example, the 245I law was part of the Defense Appropriations Act in 2000, December of 2000. So there's a history of doing this. The only question is, will the person that makes the decision about whether or not an immigration bill can be part of the reconciliation bill is someone called the parliamentarian. The parliamentarian is the maker of rules. I think there's a song about this, the maker of rules. or the maker of fools. I'm not really quite sure which it is, but she gets to decide whether the immigration bill has a sufficient budgetary impact to be included in the reconciliation bill. And if she concludes that it does, then they can include it. And they include a lot of different immigration bills in there, each judged on its own merit. Now, she hasn't made that decision yet because they haven't given her the reconciliation bill. And of course, if she says no, then they're going to find some other vehicle to pass these bills. So let's talk about what we know will be included in the reconciliation bill and the rumors that we have heard about what might be included in the reconciliation bill. So we know in the reconciliation bill there will be the DREAM Act. This is for kids. This is DACA kids plus an expansion of the DREAM Act. So up until, I think it's entries before 2017, under the age of 16, in high school, college, military. You can join the military if you're undocumented. But and basically they give you a path to residence. It's awesome. It's a great bill. Okay. It's what we've been fighting for 17, 18 years. The second component is called the Promise Act. The Promise Act is basically for El Salvadorans and Hondurans and a few other countries with a long-term TPS, which basically says, look, you've been on TPS for over 20 years. Here's a path to a green card. Great. There's probably, for as far as the DREAM Act, million and a half people. TPS bill, a little under 1 million people. The third thing that we know is in this bill, which is supported by a lot of Republicans, by the way, is the agricultural worker bill. So if you've been working in ag and you're undocumented, you're working as a dairyman, or you're working on a farm, or you're working as picking cotton or fruit and stuff like that, give you a path to a green card as well. All right, not citizen. None of these people get citizenship anytime soon, but there's a path to legality. They get a work permit. They ultimately get a green card if they comply with all the rules. And of course, they're excluded. You have any criminal convictions, blah blah blah, lots of exclusions, but a lot of people will get relief. And there's probably 2-3 million of those people, is my guess. Some people say more, but I don't think there's any more than that. I think more than that, they're fooling themselves about how many people there actually are. We know those three things would be in a reconciliation bill if it's authorized. We know that. So they're all fine. What else would be in that bill? Well, somebody asked me earlier, what about EB-5? Will there be a EB-5 reauthorization in that bill? Good question. My guess is probably not. Probably not. And my guess about that is because they're not just going to reauthorize EB-5. This is an opportunity for all the EB-5 guys out there that detest the EB-5 program to try to make it harder. Well, first, they're obviously going to raise the limit, right? They're going to go back up to 900,000 or higher. They could go higher. It could be $5 million. Who knows what they're going to do? Plus, they want to put more safeguards on it. They want to make it really more focused in rural and high unemployment areas instead of aggregating zip codes and census tracts and all the crap they're doing now. So I do not see the EB-5 program being reauthorized in a reconciliation bill. What I do see, by the way, on the EB-5 program and the rumors that I hear from my contacts up on Capitol Hill is that they could reaffirm the Regional Center EB-5 program in September when they have to reaffirm the E-Verify and the religious worker bills. So there is that. A lot of talk recently about what is euphemistically called the Eagle Act now, which is the same bill as last year on getting rid of per country limits. Obviously, a lot of opposition to that bill, and not because people are racist, but actually because it damages people from around the world that would thus not have an equal opportunity, unless, of course, we win our bill, we win our lawsuit, and all of a sudden there are no backlogs. If there are no backlogs, then do you need a per country limit? It's a good question. I mean, the fight now is, the opposition to a lifting of the per country limits is not based on race, because India is not a race, for example, because India and Pakistan are the same race, and Pakistan is not complaining about this. It is about equality. And does everybody have an equal opportunity? It's the same thing we argued in the H1b case, an equal and fair opportunity. And there wouldn't be an equal and fair opportunity if one country overwhelms the system. That's just kind of the way it is. And you can attack me for being wrong about that, but that's not racist. That's just about equality. Now, will that be in this bill? It is a wildly controversial bill. Whereas DACA, the Dream, Ag, they're not controversial, really, within the party, within the Democratic Party, they're not controversial. Now, that said, Zoe Lofgren is the master of immigration. And she was forced to resubmit this bill by her constituents, the tech companies in Silicon Valley that she represents. And it's in the bill. So she might be able to get it in the bill. As of right now, I don't think it's going to be in the bill. I don't. There's also a lot of opposition that is obviously marshaling against that bill. Notice I haven't said a whole lot about it, but I mean, I just know that there is. So we'll see. There's also a lot of work being done. Sorry. I shouldn't have eaten those French fries for lunch. I think that's what it was. We also are hearing that there will not be a general legalization. Hey, you've been here 20 years, you get a work permit. That is definitely not going to be in a reconciliation bill. That's just not. There's just a lot more opposition to that, almost uniform among Republicans. And even though they don't need Republicans for reconciliation, there are some Democrats that are kind of Republican, people like Kristen Sinema. So I don't see, whereas she can get by with TPS, the promise, she can get by with Dream, she can get by with Ag, probably can't get by with a general legalization bill. Neither can Manchin. So I think that's what it's going to be in the reconciliation bill, and then we'll see. We'll see what's going on. All right, let's take your questions here. I want to get rid of this banner. I'll get your questions here. Let's see what we got. We've got, hello, sir. I'm Maroon Issa from Lebanon. Go play to submitted documents as per request of C2C. Neither embassy. Well, yours not over yet, and our lawsuit's not over. So keep your patience. We've got a number of Go plaintiffs have been contacting us that they've been scheduled for interviews. One was just interviewed today, and they said you're going to be approved. We're going to send you the passport shortly. So kind of good news. Mariette, keep the faith. Still fighting. And that's why we're seeking to reserve the visas too. They're just not going to get to everybody, likely. I mean, they could. I mean, they're physically capable of getting to all of our clients. But I just don't know if they will. So we'll see. But we hope to hear from the judge soon. Ronald DaCosta, good to see you. Anoa, good to see you. Let's see. We know from Gomez, is Eunice, that the PI relief is until September 30 and needs to have a final judgment of reservations. But you know, it's asking, the lawsuit's asking, we'll be waiting while go. Oh, I think that's quite possible. We're going to have final judgment, which is strategically the smart thing to do. It's strategically the smart thing to do. And that's why I believe that our clients are going to get interviewed. Hassan, you don't love me as much as my wife does. Volkan, hypothetical question about visa DV reservation to go. Do you think other laws have to wait for their final decision by the judge? Well, no, I think other people, I mean, they're not just going to do, first of all, we probably only have less than 900 plaintiffs left to be interviewed, or their families total. I think total was like almost 988 people, but they weren't, there were families in there, right? So it's not 900 different interviews. So no, I don't think they're going to be waiting. I think other lawsuits will get interviews as well, because they're obviously capable of doing 6,000 to 7,000, 8,000 a month. So hopefully that answers. Can Go plaintiffs adjudicate in October after? Well, that's what we're fighting for, my friend. Katie Oliver, I go, what do you think of your final decision? Katie, everybody, what is your best guess? You know, Judge Maida is going to take the time he believes he needs to make a decision on the case. It's quite clear from an order today in the Good Luck case that somebody tweeted to me that the government asked for more time to answer the complaint, which they don't have to do in the preliminary injunction. He gave them until the order is issued. So I don't know. You know, he gave them 2 weeks, but I don't know. It's a good question. I would hope soon. But keep in mind, it took us a couple of weeks to write our complaints, and then the preliminary injunctions, the motion for summary judgment. That takes time. The judge has to do all the same thing. Now, some would say, we'll just copy last year's order from Go. Well, and from Acker and Gomez, true, you could do that. But this is a different kind of case. So, and the facts are overwhelmingly against the State Department now. I mean, they literally chose this year not to do these cases. I mean, they literally shoved it in the judge's face. We are choosing not to do this. We are choosing not to follow what you said. Now, some people asked recently, what if they do the same thing in October? Then we will sue them in November. For all you DV 2022 people, watch this space. We will be in touch if they decide to do it again. No, Mariette, nobody pushes a federal judge to do anything ever. Just take those words out of your brain. It does not happen. All right. David Echevarría, Luces de Cuba. Seguimos esperando noticias. Nosotros también, hermano, las estamos esperando. Go. My son will turn 21 next June. Well, if you are not adjudicated, Liz, by the end of the year, contact us because that's a different issue, which we're happy to help with. Wasem, DB 2021, waiting for Me Too. Interviews, yeah, Montreal. Think about that. Canada, the U.S. consulate in Canada, I believe, if it's not the worst on doing interviews, it's probably second. The only other consulate I can think is worse is Manila, off the top of my head. All right. Verónica de Log, buenas tardes. ¿Sabe usted qué va a pasar con las familias que inmigración los ha liberado estos últimos meses? Una amiga tiene corte el próximo mes porque viene con sus hijos. Mil gracias, ya tenemos la cita para una conversación. Well, hablaremos de eso en su cita, pero van a procesarlos rápido. Ya han dicho, los que han suelto tendrán audiencias rápidos. Es lo que va a pasar. When can we expect a final decision? Soon. The Clorox. It's the Clorox. The Clorox. I don't know. Is that like a word from Harry Potter? Hypothetical question. Everybody already asked this question. Stop asking this question. You only have to do it once. Let's see. Gomez and Go get adjudicated together because the same nature will be final. Oh, yeah, they're going to be final. I mean, by September for sure. I mean, no doubt about that. Yesterday, government's council sought an extension of the deadline to file a response. No. That's not what they got an extension to file an answer to the complaint, not the PI. Different thing. And they've waived answers in the Go case. So no, will not happen in Go. Don't worry. Latest update on your H1b. Well, Rajesh, we don't have an H4 EAD delay case. We were never hired by anybody to do that. We put word out, but nobody wanted. They figured to go with somebody else. Our good friends at Bonius and Wasden Bonius, they have a number of cases on this, and they both won and lost. And the problem is the H4 EAD, the way the rules are written, it's a discretionary decision. And it's just a lot harder to win those cases. And it really depends on the judge that you get in some ways. So no, we don't have that case. I'd encourage you to check out Bonius and Wasden's website. They've got that information. Why Department of State does not include as defendant? Because none of our clients are at a consulate. No, it's not within their authority to reserve visas because here's what USIS needs to do. First of all, they can ask for all the visas and reserve them. Second, they can assign. The other thing they can do is they can assign the visas at the time of filing. They don't right now. USCIS reserves the visas, reserves them when they go to approve the case. But instead, they should reserve them when a case comes in, which actually is a much better metric to use by. And then if somebody's not approved, they can return that number. But that's what they're not doing. So that's why we don't need the Department of State. But thank you, Urshad, for your legal analysis. Sir from Lebanon, Go plaintiff, the only plaintiff on your list. Will it be an advantage for me after the decision to get my yes. How do we argue against USCIS and COVID delays? Well, first of all, Urshad, thank you for asking the government's question here. USCIS has been working since last June. They've been working all year. The service centers, which do over half of these cases, and which should be doing most of them, by the way, most of those adjudicators work from home. They work from home. So what's stopping them from working? Any idea? Yeah, me neither. Me neither. I'm looking for that explanation. Orcan, today the government response, good luck, was delayed to the answer to the complaint. That's it. Answer to the complaint. Friday, Ferdinand thinks it's Friday. All right, Ferdinand, there you go. You put your name on the line. You said Ferdinand thinks it's on Friday. Well, I hope you're right. Saira Valle, my husband sent a petition for advance parole in March and sent that with his mom. He has DOC and his mom has TPS. His mom received the approval, but he hasn't. Can he call USCIS? Yes, he can. 1-800-USELESS. 1-800-USELESS. If he doesn't have an emergency, they're just going to tell him to wait. If he's got an emergency, they're going to ask for proof. All right? Hopefully he's got an emergency. Sid, I talked about the reauthorization already earlier. You can head back to the discussion about the reconciliation bill. Brenda, buenas tardes. En septiembre vine a USAE con la visa turista. En febrero llené el formulario para extender mi estadía y mi cambio de estatus a F1. Ya me llamaron para hacer las huellas para ambos casos. Tengo dos preguntas. ¿Para qué pueden aprobar mi F1? ¿Me tienen que llamar para una entrevista? No, no hay entrevistas. La siguiente pregunta es si he visto a la página de Facebook que ya no se tiene que extender su estadía. Es correcto. Ya no tiene que meter un otro B2. No se preocupe de esto. Buena suerte con eso. La F1 es horrible. Otra litigación que tenemos que hacer. Shabnan, can you please explain the difference between preliminary injunction and summary judgment? Oh, let me do that first. So, preliminary injunction is a preliminary judgment and in advance judgment of the case where in order to get that, we have to show there's a substantial likelihood that we will win and that somebody will be harmed if we don't get that order now. Where summary judgment is a balancing of the case on a scale. And if our arguments are better by 0.1%, we win. Regardless of harm. Okay, we win. If our arguments are correct, we win. Period, end of story. So it's an easier, summary judgment is an easier burden for us to carry. It also is the final judgment. Whereas anybody who knows about the the Gomez case knows, preliminary, but no final judgment. So the judge's order had to end when the preliminary period ended and did not continue, which is why we had the problem that ended up in Go, because there was no final decision. All right. Hopefully that helps. Advantages for summary judgment. Our order is final. They got to adjudicate on our clients, preferably before the end of the year. That's the case. Whereas a PI is probably try your best. Douglas, yes, they do. They actually are hiring. We had a meeting with our local office this morning. Said they're hiring more officers at the local office. I mean, I imagine they're probably going to be hiring hundreds of people around the country. I mean, they were starved. They were starved during the incompetence of the Trumpasso administration. Claudia Aguilera, I have a DACA and expires in December, but I need to ask for parole. Can I do both? Yes. Parole's been taking 3 to 5 months. DACA has been taking 2 to 5 months. You should have applied in June. You need to get it in now, 6 months beforehand. If an uncle is sick, that's a good letter. Get a letter from the uncle, prove your relationship, and put that in there. Shabnan, second question. As a Go plaintiff, if we get everything in September, we don't get the visa in September and we get AP, we'll be fine in September. Well, you can't get the visa unless the AP clears. No visa unless you clear administrative processing. But we're asking for these visas to be reserved so they can be issued next year. So that's the key component for those of you who will be subject to administrative processing. Thank you, Shaw. I appreciate you listening in. I mean, it was really, really an important argument. And I certainly enjoyed doing it. And I think frankly, I think we had the better argument, but that's just me. Let's see. We just jumped ahead a little bit here. Missed the first one. What part of the bill will relate to the H1b? None. The reconciliation bill has no H1b components in it that I'm aware of. None. What are the chances of getting a TRO approved? Well, in the H case, none, because he already denied it. On the adjustment of status case, none, because we're not asking for it. So I don't know what case you're talking about, Yohal. Let's see. Wisdom, do you not answer my question? I did answer your question. You will be processed. If the judge orders it, you will be processed if you're a plaintiff. Period. Magdalena, metí la 130 para mi hijastra en diciembre 2020. Nos aprobaron todo. Ya soy ciudadana americana. Ella está en México. Ya tiene 19. Ya nos aprobaron todo solo. Es una entrevista en Juárez y están avanzando con eso. Ok. Están tomando 18, 24 meses por entrevistas en Juárez. Está cerca, la única cosa que te puedo decir. Está cerca. Ojalá has cumplido todos los procesos por el consulado. When do you expect AOS case to be adjudicated? By middle of September, if not earlier. That's kind of our goal. That's why we're going to file a preliminary injunction. Johnny Marcano, hola desde Austin. My cousin was just released to me. I'm a U.S. citizen from a correction center in Louisiana. Well, you are not. Is that a misplaced comma? Is that an Oxford comma? 21 is court hearing December 8th. No, there's no work permit unless he files for asylum, Johnny. If he has a fear of going back to his home country, he should immediately file an asylum case. And then 150 days after filing, he will be eligible to apply for a work permit. Okay. H1b case for the next government hearing. Will you ask U.S. to remove? Yes, that is exactly what we're asking for. So, well, actually what we're asking them for, the judge for, is to get rid of the lottery and put them back to the previous lottery, or make them redo the regulation such that, or amend the regulation that you can't submit duplicates from multiple employers, or to put into place stringent evidence that an employment offer is real, with penalties if it's not, or to raise the fee. I mean, raise the fee. $10 is not a bar to entry. Raise the fee to $1,000, and then deduct and put that towards some benefit. And real employers will pay it. Real employers will pay the fee. Fake employers won't. No, supposedly. We'll see. Johnny, en español, tu primo, tiene que meter su aplicación de asilo tan pronto como sea posible. Y 150 días después de que mete su aplicación de asilo, puede aplicar por un permiso de trabajo. Entonces, es esencial que él trabaje fuerte con un abogado bueno tan pronto como sea posible. Katie, how can I make sure my derivative husband is also included in my case? Well, I assume that he is and has completed the processing at the KCC. That's how he's included in the case. No other need to do that. Let's see. Again, I can't, nobody knows by when, if the judge reserves numbers, when they have to be completed by. I don't know the answer to that question. Let's see. Sarah, what can we do for a work permit request delay? I submit the April and March 2nd. It's a pending. Oh, Sarah, they're taking 6 months, 8 months. Nothing you can do. I mean, you can sue them, but you've only been pending 5 months. You're unfortunately well within their normal time. And I mean, you can sue. That's really all you can do beyond that. Unfortunately, I wish there was a better option. Vignesh, my visa will be expiring in 2 months' time. Will there be a request for visa status? And I can play for like me until. No, because we don't have, Vignesh, we don't have a legal basis to ask for that. Just don't. That's why it's not in there. Every time you file a complaint, there's lots of things you want to ask for, but unless you have a legal argument, supporting law to ask for it, you can't ask for it. I mean, you can ask for it, but you're going to look like a jerk because you're asking for stuff that you can't get, and that makes you look like a crappy lawyer. So unfortunately, no. What you would have to do in your case is, if you want to stay in the country, is file for a B2 change of status, and that lets you stay in the United States. I mean, that's unfortunately the only option right now, unless we win this next PI part of the complaint. All right. Rose Bay, got to go. Do you think DOS adjudicate Iranians as embassies? Yes, I do, because I mentioned that to the judge, and I think he's going to put that in his order. And of course, the government's going to have reports to the judge every couple of weeks, in which we're going to have a conference. And we're going to say, Judge, we got a serious problem here. They're not adjudicating Iranians. They're not adjudicating Russians. They're not adjudicating Afghans. They're not adjudicating Iraqis. They've got to figure something out, and they're not doing it. We want them to tell you what they're going to do about these. All right. Yuha, I just talked about in the H1b section what I'm going to do. All right. Let's see. Will the judge reserve visas independently? Well, he could. I mean, one of the alternative forms of relief that we ask the judge for is reserve enough visas for our plaintiffs. If he doesn't want to reserve all of them, reserve them for our plaintiffs. So that's why we're fighting for our plaintiffs. Let's see. What needs to be proved for a parole? Basically, a doctor's note and then proof that you're there to your relative. mi santísimo tío está enfermo. Un doctor del doctor dice, tío Pablo es muy enfermo de tal y tal y tal, y no tiene mucho tiempo para estar bien. Es todo. Una carta fácil. Su abogado puede darte con un ejemplo. Will you see a third round? I talked earlier about this. I think there's a decent chance for a third round. Again, immigration has not been public about how many they've approved and how many they've denied. They haven't told us. And where they got the 27,000 number from. We know they didn't approve all 65,000 last year. We know that because they said they didn't. So where are they this year? They're intentionally opaque about this. Intentionally opaque. U.S. Embassy in Turkmenistan is no better than Montreal. Well, that is better than Montreal because they issued 4. Montreal issued none. Ashwin, for AOS Delay litigation, if all the plaintiff cases are adjudicated in mid-center, will that be the end of litigation? Yes. That would be the end of litigation. And it's possible that only plaintiffs are adjudicated. But they haven't played that game very well. They just haven't. They literally could make the case go away by saying, give us the list. Boom, interview, approve. They could do that. And if they didn't want a decision on the case, that's exactly what they would do. And we'd be forced to dismiss the case. Would you say the EB backlog will be close to current in a couple of years? Yes, I do. Actually, I think it's 3 years. It will be close to current with the math that I talked about earlier. Because if you got 250,000 people every year in the EB category, first of all, you only have 300,000 cases pending. There are only 300,000 adjustments that are at immigration. So virtually all of them could be taken care of today with the numbers that if they're reserved. Okay, they could all be done today. And then you got 2 more years dumping 500,000 cases every year into the system. Well, what do you think? You can do the math as well as I can. I think we at least get to 75%, which is a massive difference from waiting for 100 years to waiting for 4 or 5 years in a process. Very different. Keep in mind, my Mexican friends have been waiting for decades for all their cases. So, by the way, if we are going to get rid of per country limits, they better get rid of family limits too. That ultimately is my big thing. Get rid of them all. Get rid of them all. And then you can argue fairness. But if you're just asking just for us, then that's not fair. Let's be honest about it. That's not fair. Can we ask the judge to reserve H1b plaintiffs? No, we can't. No, we can't. Because that is also not fair. It's also not fair. So no, and the judge wouldn't do that. All right, everybody. It has been great to talk to you today. Man, I love doing these. I love doing these Facebook Lives, YouTube Lives, Twitter Lives, I guess. I don't know. I should have been on Twitter. I just don't know if I was and whether it showed or not. My Twitter's not up, so I don't know if it's showing or not. But hopefully it is. And if it is, welcome to our Facebook Live. Thank you, everybody. Again, if you have any questions, you call. If you want to consult, we have 13 lawyers, 50 staff. All we do is every area of immigration: family, employment, asylum, removal, EB-5 investors. We do it. Federal, and of course, federal court litigation. Llámenos. Estamos aquí para ayudar a todos. Lo que tiene que hacer es llamar por la cita. Tenemos abogados haciendo consultas gratis. Yo no, pero tenemos que estar haciéndolos. Puedes hablar con ellos. Si quieres hablar conmigo, se paga, por supuesto. Pero estamos aquí para ayudar a toda la comunidad. Gracias a todos. Welcome, everybody, again. Have an awesome week. We will see you on Monday night on our Impact Litigation.